All right, court will resume here with the May 4th, 2022 docket, and we're live stream. And I have here first CL 2109 70D Evangelina Blanco versus Walmart stores. And I believe we're here on a motion for summary judgment. Is that what defendant's motion, right?
That's
Yes,
correct.
Judge.
All right, and that'll be Mr. Caso, right, sir?
That's correct, Judge. Good morning.
Good morning, sir. You're here standing in for Jaime Sáenz?
Yes, sir. That's correct.
Okay, for the record, you're Jacob Caso for the Walmart stores, and we have also Mr. Martin Perez for Ms. Blanco.
Yes, Judge.
All right, Mr. Caso, you may proceed, sir.
Thank you, Judge. As you stated earlier, we're here on defendant's no evidence motion for summary judgment. I'm just going to give you a brief refresher of the background facts on this case, Judge.
Okay.
According to plaintiff's original petition, Ms. Blanco visited the Walmart store in Hidalgo, Texas on May 9th for the purpose of conducting some shopping at the store. While she was at the store, she'd been there for about approximately 20 to 30 minutes. Before that, she entered the store to shop for some air fresheners. And when she was in the home goods section, she slipped and fell on what is believed to be liquid detergent. Blanco's testimony states that she did not see any Walmart personnel in the immediate area before her slip and fall incident. She also testified that she did not see the condition before her incident occurred, and she also does not know how long the condition was on the floor prior to her slip and fall accident. Although Ms. Blanco does testify that an unidentified person who allegedly worked for Walmart stated that the condition had been on the floor, that person had knowledge of the condition on the floor prior to the incident. If you review the surveillance footage, Your Honor, you can see that the spill was created for a very short period of time before Ms. Blanco's slip and fall incident, about 2 minutes. And during that time, there's no evidence to suggest that any Walmart store personnel were in that area or saw the condition. Judge, we're here, as like I stated before, on our motion for summary judgment. And just to give you a refresher on a premises liability cause of action, Ms. Blanco needs to prove 3 elements in order to succeed on her claim. The elements are actual or constructive knowledge of a condition on the premises, that the condition posed an unreasonable risk of harm to Ms. Blanco, that the owner or occupier, in this case Walmart, did not exercise reasonable care to reduce or eliminate that risk. And the 4th element, Your Honor, is that the owner or occupier's failure to exercise such care approximately caused plaintiff's injuries. Judge, we're going to be arguing that there is no evidence to support that first element, that Walmart did not possess actual or constructive knowledge of the condition at issue. As a refresher, Judge, a no evidence motion for summary judgment is properly granted if the non-movement in this case fails to produce more than a scintilla of evidence to raise a genuine issue of material fact as to an essential element, in this case, the first element of this premises liability cause of action. And a no evidence motion for summary judgment places that burden of presenting evidence squarely on the non-movement, in this case, Ms. Blanco. Judge, although plaintiff's counsel doesn't address or argue against the actual notice element, we're still going to go through it very briefly. Judge, as a refresher, actual knowledge requires knowledge that the dangerous condition existed for a period of time prior to the incident, and that Walmart actually had knowledge of that condition. In this case, Ms. Blanco hasn't presented any evidence that Walmart actually had knowledge of the condition, although Ms. Blanco does state that an unknown Walmart associate allegedly told her that he had notice of a condition. If you review the surveillance footage, as I've mentioned before, the surveillance footage depicts the condition on the floor for just less than 2 minutes before the incident, and no Walmart employees are seen in the area with knowledge of that condition. If we go into the constructive knowledge element, Judge, in order to hold Walmart liable on the basis that it had constructive knowledge of the condition, Ms. Blanco must raise a fact issue regarding whether the condition existed for a long enough period of time to give Walmart an actual reasonable time to discover the condition. Like I stated before, Your Honor, if you review the surveillance footage, I don't believe, and Walmart's position is that 2 minutes is not a sufficient amount of time to discover the condition and remedy the condition at issue. That's basically a summary of our argument, Judge, and we think that we've presented enough evidence to support that argument, and that Ms. Blanco does not have enough evidence to defeat us on this no evidence motion for summary judgment.
All right, thank you, sir. Mr. Martin Perez.
Yes, Judge. First of all, I mean, on the actual notice, Judge, I mean, an employee did tell her that he knew about it, and she had been there for 15, 20 minutes. So we feel that there is actual knowledge. But in the alternative, Judge, Ms. Blanco only has to present a scintilla evidence that there is a genuine issue of material fact. We're watching the surveillance video. It's not really clear when the condition is created, Judge. We disagree that it was 2 minutes, and so we invite the court to review the surveillance video. Judge, right before the video, I mean, right before she falls, you see customers slipping and looking down at the condition. And a few minutes before the incident, you see a Walmart employee not even 6 feet away, but not paying any attention. And for the entire 30 minutes, you see an hour's worth of video, and you never see a Walmart employee inspecting the area. And I mean, there's, I mean, according to the law, they're supposed to do that. I mean, the law states that the condition had to exist long enough for the premises owner to have found it after a reasonable time for inspection. An hour, I think, is a reasonable time for inspection, Judge. And you never see any employee inspecting the area whatsoever. And then a few minutes before the incident, you see an employee working with some sort of shelf, not paying any attention to the area for any dangerous conditions. So, we feel that is enough evidence, Judge. I mean, at least at this point, there is a fact issue here. And so at this point, we feel that Ms. Blanco, she feels she has presented an issue and that it should go forward, and she does defeat this no evidence for summary judgment.
Anything else, Mr. Castle, briefly?
Excuse me, Your Honor. Sorry, I was on mute. Nothing further, Your Honor. I just want to invite you again to please take a look at that surveillance footage.
I will.
We don't get a lot of opportunity to actually get a lot of these incidents on surveillance footage, and this one does seem to show a customer 2 minutes before the incident create this condition on the floor, and that's basically the basis for Walmart's no evidence motion for summary judgment.
All right, then court will take judicial notice of the entire file. We'll take the matter under advisement, and we'll go ahead and consider the argument of counsel, and of course, we'll look at the video. So that'll do it. Thank you all very much, gentlemen. Have a great day and stay safe.
Thank you, Judge.
Thank you. Bye-bye. Number 2. All right. How about CL 21-15-26D? That'll be Eileen Medrano Garcia and Gregorio Belmares as next friends of minor versus Carolina Bazan. All right.
Good morning, Your Honor. Graciela Orellana here for the plaintiffs.
Your Honor, good morning. Victor Quintanilla on behalf of the defendant. How are you, sir?
Fine. Thank you. Morning.
Good morning, Judge. Cesar Lopez Singletary here as that liner for the minor child, Sarah Medrano.
Good morning, ma'am. And good morning, everybody. Good morning, the Belmares and Medrano family. Good morning, folks.
Good morning.
All right. Are we ready, folks, on this one?
Yes, Judge.
We're going to hear some testimony from which one? Both or just one?
We can ask the questions to Miss Eileen, Your Honor.
Miss Eileen? Okay. So good morning, Miss Eileen Medrano Garcia. Please raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may put your hand down and listen carefully to the questions. You're going to get started, Miss Oriana?
Get started, Your Honor. Yes, thank you.
You may proceed.
Miss Eileen, can you please state your full name for the record?
Eileen Garcia Medrano?
And you are the mother of Sarah Medrano, correct?
Yes.
And next to you is your husband, Mr. Gregorio Medrano, correct?
Yes.
And he's the father of Sarah Medrano?
Yes.
Okay. And we're here today because of an accident that happened back in October of 2020 here in Hidalgo County, correct?
Yes, ma'am.
As a result of that accident, Sarah was injured in that car accident, correct?
Yes.
And she received treatment for those injuries, correct?
Yes.
And she is doing well today. Her injuries have resolved.
Yes, ma'am.
And we're here today because you have reached an agreement on behalf of Sarah with the defendant on this case, correct?
Yes.
They've agreed to pay $11,650 to settle her case, correct?
Yes.
Of this total amount, you are asking the court to pay $8,716.94 to the law office of Ezequiel Reina for medical expenses, case expenses, and attorney's fees, correct?
Yes, ma'am.
And $2,933.06 will be deposited into an interest-bearing account in the registry of the court for the use and benefit of Sarah, correct?
Yes.
You realize that once the judge approves this settlement, you will not be able to come back and try to reopen the case, correct?
Yes.
And the money deposited into the registry of the court is for the use and benefit of the child, and you will not be able to withdraw the money without permission of the court. You understand this, correct?
Yes.
And you understand that we are here today to announce a settlement, and you are asking the judge to approve this settlement, correct?
Yes, ma'am.
Mr. Medrano, you've heard the questions that I've just asked Ms. Eileen, correct?
Yes, ma'am.
Judge, may you please swear him in?
Okay, you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Judge.
Thank you, sir. You may put your hand down.
Sir, if you can please state your full name for the record.
Gregorio Medrano Belmares.
And you've listened to the questions that I just asked of your wife, Ms. Eileen?
Yes, ma'am.
And you are in agreement with her responses to these questions?
Yes.
I have no further questions for the witnesses, Your Honor.
All right, thank you, ma'am. Mr. Quintanilla?
Yes, Your Honor. Ms. Eileen, good morning to you once again, ma'am.
Good morning, sir.
I represent the driver of the other car that was involved in the accident, okay?
Okay.
Now, you heard Ms. Orellana ask you the questions about the money that you agreed to accept on behalf of your daughter, right?
Yes.
Okay.
Yes.
And in doing so, you understand that if the court approves this settlement between us, then you will not be able to come back to this court or any other court to continue any type of claims on behalf of your daughter in connection with this subject accident.
Yes, I understand.
And you understand that in the same that your daughter, when she turns of age, if the court approves this settlement right now, she will not be able to do so either. You understand that?
Yes.
Right. And you understand that under the law, you have every right to ask for a jury trial to listen to the merits of this case against my client, Ms. Bazan.
Yes.
And are you waiving the right to a jury trial for Sarah?
Yes, I am.
And do you believe that it's in her best interest that you waive that right to a jury?
Yes.
Right. And now, Sarah is in what grade is she in right now?
4th.
Is she going to school in person or virtually?
In person.
And since this accident happened, has she resumed her normal daily activity?
Yes.
She's been going to school and she's been, doing everything that a child her age does.
Yes, sir.
Has any doctor, any healthcare provider informed you that Sarah somehow sustained a permanent injury as a result of this car accident?
No.
And again, you understand that those monies will be deposited in what we call the registry of the court for Sarah's behalf.
Yes, sir.
And Sarah's benefit.
Yes, sir.
And it will be done so in an interest-bearing account. You understand that?
Yes.
And do you believe that that's in her best interest?
Yes.
Do you believe that it's in her best interest that the court approve this settlement between us?
Yes.
And do you agree to cooperate and sign a full and final release on behalf of Sarah so we can get this matter concluded?
Yes.
And you and Mr. Belmares are authorized to sign that release, correct?
Yes.
Thank you, Ms. Eileen, for your time. I wish you the best. I wish you and Sarah the best. And Your Honor, I have one question for Mr. Belmares.
Yes, sir.
Mr. Belmares, good morning once again, sir.
Yes, good morning.
You heard every question that I've asked of Ms. Eileen.
Yes, I did.
And are your answers the same as hers?
Yes.
All right. I thank you for your time, sir, and I wish you the very best with your daughter. And pass the witness, Your Honor.
All right, thank you, sir. Ms. Singletary, you may proceed, ma'am.
Yes, Your Honor. My announcement, Your Honor, is that I've consulted with a family in my office, Ms. Eileen Medrano and the minor child. I've reviewed all the medical records on her file. I find that Sarah has been discharged from all her doctors and that all the injuries that are arising out of this accident have resolved. I find, Your Honor, this is also a fair settlement and that it's in the best interest that this case be settled today. I spoke to Ms. Medrano and I went over some of the same questions that Mr. Quintanilla just went on. So, Ms. Medrano, good morning. How are you?
Good morning, good ma'am.
Okay. And we went over the same thing. I let you know that this settlement is for the benefit of Sarah, that it's going to be placed in the registry of the court and that she will not be able to be accessible until she turns 18. Is that correct?
Yes,
Okay, so Judge, I have no further questions. The only thing that I was pending from Ms. Medrano that we spoke about yesterday is the birth certificate and the social so I can deposit the checks whenever I receive them, Your Honor.
All right, very well. That's good. Court will then take judicial notice of the entire file in the case of Eileen Medrano and Gregorio Belmares as next friend of Sarah, minor child, versus Carolina Bazan. Court will hereby approve the minor's settlement and we'll go ahead and await a judgment for signature. Anything else from anybody?
Your Honor, I did prepare an agreed final judgment. I circulated to both Ms. Lopez Singletary and Ms. Orellana, Judge. I don't recall right now if both have signed off on it, but if not, the only other issue is between Ms. Lopez Singletary and myself on the fees.
Okay.
I know I got a statement from her, an invoice.
Okay.
Not authorized to accept it, Judge, but if her and I can maybe talk about it between
Sure.
us,
Sure.
and come back to the court and then we can fill in the blank on the order, Judge.
Right, you can do that.
Well, Your
Yeah.
Honor, I submitted my itemized statement, Your Honor, and I'll leave it up to the court what the court wants to do, Judge, but I have submitted to Mr. Quintanilla.
Okay. All right, I'll give you times. I'll give you all both time to review and go over it. And but yeah, submit it with the blank. Something if you don't agree, let me know. Other than that, court will hereby approve the minor settlement. And like I said, the court will await a judgment for signature. You all stay safe, have a great day, and be careful out there.
Thank you, Your Honor.
Thank you, likewise, Judge.
Thank you, Counselor.
Thank you all.
Bye-bye.
Bye-bye.
bye.
Bye-bye.
Number 7.
Number 7. All right. Number 7, Mr. Weissenhan. There he is.
There you are, Your Honor. Good morning.
All right, good morning. Next case here, CL 21-3864D, and that'll be Encore Title LLC versus Brendan Mcdonald. And we have here, it's a default judgment hearing?
Yes, Your Honor. I don't know if Mr. McDonald's appearing via Zoom or he has not filed an answer that I'm aware of, Judge, or made any type of other general appearance.
All right, Mr. McDonald, good morning, sir.
Good morning, Judge.
Okay.
You don't have an attorney, sir?
No, sir. I wanted to request more time. Unfortunately, being in Dallas and trying to obtain representation in South Texas, I've been unsuccessful due to, as soon as I mention names, I'm told that there's conflicts of interest with attorneys that I tried to reach out to. I am still trying to obtain someone, so I'd like to request a little bit more time, please.
Okay, so today we were set for default judgment. You need to file a written answer to the lawsuit, and we'll grant you some time here.
Yes,
I
sir.
guess we'll set it. I guess we'll set it again for either default judgment or maybe even trial on the merits, Mr. Weissenhan. Submit an order, and I'll put a date in there. It'll be
Okay.
either or, either default judgment or trial on the merits.
I submit it to your office, sir.
No, no, you submit an answer to the court, to the clerk's office.
To the clerk's office.
An answer
Okay.
to the lawsuit, yes, an original answer there. And meanwhile, Mr. Weissenhan will send me an order for another default judgment hearing or trial on the merits.
Or trial on the merits, Your Honor. Very
Right.
good.
It'll be like 60
Okay.
days from now or something like that.
Okay.
Okay.
Very well, Judge. Yep.
All right. That'll give us plenty of time, Mr. McDonald, to find somebody. Or if not, you're going to have to be defending the case yourself. Okay, sir?
Thank you, Your Honor. I appreciate it.
All right. You all stay safe out there. Good luck.
You too,
Likewise.
Your Honor. Thank you.
Bye-bye.
Mr. Robert McLaughlin. I don't know if he's here for number 3 and number 4.
Let's find out. Mr. Robert Oh, you put him on already, Mr. McLaughlin. There he is. Good morning, sir.
Good morning, sir. Yes, sir. I'm here for number 3 on your docket.
All right, number 3, it's CL 21-32-27D, LVNV Funding LLC versus Jorge Resendez. Court will note that Jorge Resendez is not in the waiting room, and therefore, court will take judicial notice of the entire file. And you may proceed, sir.
Yes, sir. In this case, we believe that the defendant had opened up an account with On Deck Capital in August of 2017. He made his last payment in October of 2018. The account was closed and charged off with a balance of $73,451.03. And we're seeking that amount of damages plus cost of the court and post-judgment interest, and would ask the court to take notice of the business records, the non-military declaration, and certificate of last known address, and issue judgment for the plaintiff.
Court will hereby admit all exhibits and evidence in court, and also court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in his petition. Court will await a default judgment for signature. Is there another one, Mr. McLaughlin?
The only one I have with today, the default judgment was filed, but because
Okay, you're skipping Mr. McLaughlin. I didn't hear anything.
I was saying that I believe a default judgment had been filed, but an order for it had been filed, but we need to update it because of some issuance from the Supreme Court contained in it.
Okay, so then in that case, it's gonna have to be an amended order, an amended judgment? It's probably gonna have to be an amended default judgment.
Yes, sir.
Okay.
Does he have another one?
Do you have another one, Mr. McLaughlin?
No, sir, I don't believe so.
Okay. Thank you very much. You're excused. Stay safe.
You too, sir. Take
Bye-bye.
care.
Yes,
Bye.
thank you.
Ms. Garcia, number 5.
Number 5, Ms. Garcia.
Hi, good morning, Your Honor.
Good morning, ma'am. This is let me see here. Number 5, CO 21-35-37D, Jorge Luis Abrego versus Socorro. Is it Socorro? Is it Socorro and Jaime Salas or Socorro y Jaime Salas?
E.
So it's just one dependent?
Yes, Your Honor.
Okay,
Yes.
Socorro y Salas. Okay. And it's what, a motion for summary judgment?
Yes, Your Honor.
Okay. And then let's see, I'm sorry, I can't read that.
Olette.
Olette, there it is, Miss Olette. Good morning, ma'am.
Good morning.
Which is your case, Miss Olette?
I'm number 4, Discover versus Ramon Galvin.
Oh, okay, you're number 4.
Yes,
You know
Your
what, that'll be for default judgment, right?
Yes, Your Honor.
All right, let me do that one quickly here. That'll be CL 21-34-85D, Discover Bank versus Ramon E. Galvan. Court will note that Galvan is not in the waiting room or in the courthouse because I have personnel there too, and nobody's advised me that he's there. So therefore, court takes judicial notice of the entire file, and you may proceed, ma'am.
Thank you, Your Honor. So we filed our breach of contract suit on October 12, 2021. The defendant was served on November 6, 2021 by personal service. The return of service has been on file for the prerequisite amount of time. We filed our motion for default judgment on January 7, 2022 and mailed a copy to the defendant as well. We also sent notice of this default hearing to the defendant via regular and certified mail on April 20, 2022. So we are asking for default judgment in the amount of $8,558.65, as no answer has been filed, with court costs in the amount of $370.15 in post-judgment interest.
Court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in his petition. Court will await a default judgment for signature. All right, that'll do it, ma'am. Thank you so much. Your excuse.
Have a wonderful day.
Have a good day. Bye-bye. All right, Ms. Garcia.
Yes, Your Honor.
Yours is a motion for summary judgment, and it's I have here, it's Jorge Luis Abrego versus Socorro Salas.
Yes,
and
Your Honor.
Jorge Luis Abrego is pro se.
Yes.
And bailiff, let me just ask bailiff if he's heard from him.
Yes, Judge.
Bailiff, on number 5, Jorge Luis Abrego Is he there by any chance in the courtroom?
No, Your Honor, he's actually incarcerated.
Oh, he's incarcerated. Okay, okay.
So
Thank you, bailiff.
Yes, Judge.
All right, CL 21-35-37D, Jorge Luis Abrego versus Socorro E. Jaime Salas. Court will take judicial notice of the entire file, and you may proceed, Ms. Garcia.
thank you, Your Honor.
You're
Your Honor,
welcome.
this lawsuit arises from a petition filed in this court on October 18th, 2021. In this petition, plaintiff, who is Jorge Luis Abrego, and also the husband of Socorro y Jaime Salas, his petition, he is pro se, and the petition states roughly that he has some money that he believes was a stimulus check for $1,200, $2,600, and $1,400, and that Ms. Salas took out these funds from a bank account. He's also alleging that there was a van worth $1,000 and a storage shed room worth $3,500 that she took without permission. But he filed this lawsuit requesting relief in the amount of $7,700. Your Honor, we filed our answer and filed this motion for summary judgment. Here, they've been married since 2012. He's been incarcerated since 2016. They both are joint tenants of this bank account. So the money, any money that's deposited into this account is, one, is community property. Two, they're joint tenants to this account. So they're both owners on this account. So any money that is in that account could be withdrawn from anyone. Also, and I believe as Exhibit A, we provided a document of the signature card showing that they're both owners of that account. So, and then number two, any allegations regarding a stolen vehicle and a stolen shed are criminal allegations, I guess, but they're not properly before this court. This is actually a baseless lawsuit, and we're asking that that you dismiss this lawsuit.
Okay, and so he's been in, you said he's incarcerated.
Yeah.
Was he incarcerated right after he filed the lawsuit?
He was incarcerated in August 2016. And this lawsuit was filed in October 2021. So
he was incarcerated when he filed the lawsuit. Okay.
Yes. And he did respond, Your Honor. I just, in full disclosure, he did file a response asking that he's asking, I think he asks the court to appoint him an attorney so he can file for a divorce and terminating his parental rights. They also have a child together, Your Honor.
Okay. So the main remedy you're asking here on your motion for summary judgment is access to the account and the money in the account. Is that what it is?
No, Your Honor, we're asking that this motion that
the lawsuit be dismissed
entirely.
Okay.
I mean, I can go on to give more information about the money in that account and whatever, but it's a baseless lawsuit in that they're both joint tenants.
Right.
And that, him claiming that she recently took a vehicle in a storage shed that's on their property is without merit, Your Honor.
All right, then court will go ahead and take this matter under advisement. First of all, court will take judicial notice of the entire file in CL 21-35-37D in the case of Jorge Luis Abrego versus Socorro Salas. Once again, court will take judicial notice of the entire file and will go ahead and hopefully issue an judgment later this week or next week. I think that'll.
Does she have a proposal?
Oh yeah, submit your proposed judgment, okay, ma'am?
Yes, that was submitted at the time of filing.
Okay, it's already in there. All right, thank you very much. You may be excused. Have a great day, ma'am.
Thank you, Your Honor.
Thank you, ma'am. Bye-bye.
Bye-bye.
We have number 6, Mr. Jose Elias Robles is on the screen.
Uh-huh.
I am asking our bailiff if he can go out to the
Oh, yeah.
front of the courtroom to call out the name of Karen Garcia.
Okay. Next case here is cause number CL 21-3539D, Beatriz Ponce Borrego and Josue Elias Robles versus Karen T. Garcia. And I believe we have Mr. Robles.
Señor Robles, necesita oprimir el botón para sonido. Okay.
Ya lo estoy escuchando.
All right. Good morning, sir.
Buenos días.
Buenos días.
Mr. Robles.
Good morning.
Okay. And who's there next to you, sir?
¿Quién está ahí enseguida de usted, señor?
Es mi esposa, Beatriz
My
Borrego.
wife.
Is she Beatriz?
Sí.
¿Ella es Beatriz?
Sí, soy yo.
Beatriz Borrego.
Yes,
Okay.
that's me.
Beatriz Borrego and Josue Elias Robles. Okay. They're both there. Karen T. Garcia. Have you seen her? Have you heard from her?
¿Ha visto hablar con Karen Garcia?
No,
No.
Okay. Court will note that Karen T. Garcia is not in the waiting room, and court at this time will ask the bailiff to call out the name of Karen T. Garcia 3 times outside the courtroom.
Ahorita el juez acaba de notar para el record que Karen Garcia no está esperando en la sala de espera aquí en el Zoom. Le ha pedido al bailiff de la corte de nosotros de que salga ahí al frente de la corte a nombrar el nombre de ella 3 veces, a ver si contesta. Es lo que estamos esperando.
sí,
A ver si está
sí,
ella presente ahí en la corte.
sí, aquí estamos en la corte y sí, hoy escuchamos que gritó el nombre.
Yes, we're here
Judge.
outside the courtroom and we can hear that he is calling out her name.
All right. Thank you, sir. Yes, sir, bailiff.
Yes, Judge, and for the record, the name of Karen Garcia, T. Garcia, was called 3 times and there was no response.
Oh, okay.
El bailiff le acaba de indicar al juez de que él ha llamado el nombre de Karen T. Garcia 3 veces y no hay respuesta de ella.
Okay.
Okay. This was this originally a lawsuit in JP Court?
Originalmente esta demanda fue en la corte
Juez de paz.
de juez de paz.
Sí, con Jerry Muñoz.
Yes, with Jerry Muñoz.
Okay. And who won in that case?
¿Y quién ganó en esa corte?
Le dieron a Karen, pero originalmente la demanda era solo con mi esposa y en ese momento ahí me metió a mí también a la demanda y no me explicó nada más me metió, por eso apelamos.
Okay, it was for Karen. The judge ruled on Karen's behalf.
Okay.
Originally, it was just against my wife, but for some reason, they also included me on the lawsuit, and I was never explained or told anything as to why.
Okay, so Karen won in the JP level. And therefore, you and your wife appealed to this court, right?
Entonces usted y su esposa están apelando aquí a la corte de nosotros, ¿correcto?
Sí, así es.
Yes, that's
Okay.
correct.
Do you know, and I can read probably the judgment later on, but if you know, what did the JP court award Ms.
Si
Garcia?
sabe usted, por favor, ¿qué fue lo que la corte de juez de paz le concedió a Karen?
Le concedió en daños $3,000 más 146 con un interés del 5.25%.
Okay, she was granted $3,000 in damages plus $146 along with 5.25 interest.
Okay, what kind of a case was this? Was this like a car accident case? Or something?
¿Qué tipo de caso es? ¿Fue un accidente o qué es?
No, ella alega que un perro que estaba en nuestra casa la mordió.
No, she claims that a dog that was outside her house bit her.
Okay, dog bite. Okay.
Okay.
All right. Then once again, court will note that Ms. Karen Garcia is not here to prosecute her case or the appeal here in County Court 4 in cause number CL 21-3539D. Therefore, court will probably dismiss this case. Yes.
Can Rachel or Rick just check to make sure that notice did go out to her?
Oh,
please?
okay. Rick, could you verify, or Rachel, if notice was given to Karen Garcia about this?
And so they can put the address on the
About this matter?
Ahorita nada más va a verificar el personal a ver si ella recibió notificación por correo, señor Robles.
Okay.
Okay, Judge. I do have the order setting hearing. And it was mailed out to Ms. Karen T. Garcia, and I do not see a return notice.
Address.
Okay, what was the address? her address on the notice?
606 West Jones in Far, Texas, 78577.
Jones Far, Texas. Okay. It was, you said 606 West Jones.
West Jones.
Jones. Okay.
Ok, el personal de la corte ahí ahorita le acaba de decir al juez que Karen García sí se le mandó notificación por correo al domicilio de 606 West Jones en la ciudad de Far, Texas, a 78577.
Okay.
Okay. So then what court's going to do is take this matter under advisement and it's going to review all the paperwork involved here, all pleadings, including all notices to all parties, just to make sure that you did get notice as already the personnel is letting me know. But I'll review it, and in this case may be reset, maybe dismissed for federal prosecute. Okay.
Señor Robles, lo que va a hacer el juez es, va a tomar tiempo para repasar todo el expediente una vez más. Probablemente como la señora Karen García no se presentó, tal vez el juez retire el caso porque ella no está aquí para seguir adelante.
Or maybe another reset.
O tal vez a lo mejor otra audiencia. Pero si eso pasa, si el juez retira el caso, entonces usted va a recibir notificación por escrito, usted va a recibir la orden. O si el juez dice, ¿sabes qué? Vamos a ponerlo una vez más para una audiencia, entonces también igual usted recibirá notificación.
Okay.
Okay.
I'm sorry, just excuse me. And I am showing that the clerks also sent Ms. Karen Garcia an email of the order setting hearing.
Ahorita también le acaban de decir al juez que el clerk de la corte de nosotros también le mandó notificación a Karen por correo electrónico.
Okay. All right. So let me review that, and thank you all for appearing here in court. Thank you so much, and your excuse. Have a great
Muchas
day.
gracias por haberse presentado hoy en corte y que pasen un buen día.
Una pregunta, nos cambiamos de dirección. Ahorita la puedo actualizar aquí.
Sí. Yes, one more question. We just changed address. Sí, señor, por favor, deme su dirección nueva.
Es 223 East Constellation Court en Far, Texas 78577.
A ver, 223 East Constellation
Court.
Constellation Court.
Court.
Okay. In Far?
Constellation Court. En Far, ¿verdad?
Sí.
577.
Sí.
Okay, for the record, it's 223 East Constellation Court in Far, Texas, 78577.
And that is the new address for the for Mr. Robles.
Okay,
perfecto. Y el correo sigue igual. Correo electrónico que
es igual.
Es igual.
¿Esta notificación usted la recibió por correo electrónico?
No, por postal.
Okay, perfecto.
Okay, thank you very much.
Muchas gracias.
Have a great day. You're
Buen día.
Bye-bye.
Number 8, if you can just call it, there's no shows.
Okay. Next case here, cause number F0377-20-4 in the matter of the marriage of San Juanita Robledo and Lorenzo Robledo Jr. Court will note that nobody's in the waiting room, either Robledo, and I believe they're not even in person yet either, right, bailiff?
Judge, that is correct. No one has reported to the officer of the court.
All right. Court will note that there's a no-show from either Robledo in this matter. Okay, then I have, for the record here, I have P0362-20-4, Magda Gutierrez versus Joe Daniel Berrones. That is an extension, temporary orders. I'm sorry, protective order. And an extension is going to be filed in this case. And then P0392-21-4, Juana Villafana Tamez versus Abel Tamez, also a protective order and an extension to be filed as well.
That's it for tonight.